Welcome back to LexTalks, Legal Topics Simplified, a space where we try to break down complex legal concepts and make them a little easier to understand, especially for you guys, our aspiring legal eagles in India.
That's right.
So today we're diving deep into sale meaning and essentials contract of sale.
Yeah.
Um, Sounds pretty basic, right? Like we
Right.
do this every day.
It does sound basic, but you're right. There's way more to it than meets the eye.
I have a feeling.
Yeah, especially when it comes to the legal side of things.
Okay, so where do we even begin?
Well, let's start with the word sale itself. It might seem like an everyday word. You know, you go to the store, you buy something, that's a sale.
Right.
But legally speaking, it's a bit more specific.
Okay.
The Transfer of Property Act of 1882 in India, that's our guiding light here, actually defines sale in a very precise way. It's not just about exchanging goods for money.
Okay.
It's about the complete transfer of ownership from the seller to the buyer in exchange for a price. And that price can be paid in a few different ways, you know, fully upfront maybe as a promise to pay later, or even a combination of both.
So even if I'm like paying for a piece of land in installments, it's still considered a sale legally as long as the ownership is transferred.
Exactly. You got it. That's the key element here, the transfer of ownership.
Okay, that's interesting.
And here's where things get a little bit tricky.
Oh.
This whole concept of sale under the Transfer of Property Act, it mainly applies to immovable property.
Immovable.
Yeah, things like land and buildings.
So wait a minute, you saying there's like a whole different set of rules if I'm buying a car or, phone or something?
You're absolutely right. You're thinking like a true lawyer.
Okay.
For movable goods, we have the Sale and Goods Act of 1930. That's a whole other deep dive. But for now, let's stick with the Transfer of Property Act and immovable property.
All right, immovable property, got it.
Now, here's a little quirk in the law that often surprises people. Did you know that even an unregistered sale deed can sometimes be considered valid?
I think I've heard that somewhere, but it always sounded like a bit too good to be true.
It's not a loophole, but there are specific conditions that need to be met.
Okay.
It usually applies when the property value is below a certain threshold, and really importantly, the buyer has already taken possession.
That makes sense. If I've handed over the keys and they're already living there, it wouldn't be fair to invalidate the entire sale just because of a missing registration.
Precisely. The law tries to be practical and fair.
Okay, but let's go back to those movable goods for a second. How's that different?
Well, one key difference with the Sale of Goods Act is that it doesn't always require a written agreement.
Really?
Yeah.
So I could just like walk into a store, shake someone's hand, buy it a TV, and that's it.
Technically, yes. For smaller purchases, a verbal agreement can be legally binding.
Wow, that's pretty cool.
Yeah.
It's good that the law is a bit more flexible for everyday things.
Right. It would be pretty inconvenient if we needed a formal contract to buy a cup of coffee.
True, but I guess for bigger things like a house or a car, it's better to have everything in writing.
Absolutely. A written agreement protects both the buyer and the seller, provides clear documentation of the terms, avoids misunderstandings down the road.
Solid advice. All right, so before we get lost in all the specifics of each act, let's take a step back and talk about the contract of sale itself. It seems like this is kind of the foundation for any sale, whether it's land or a laptop.
You're absolutely right. The contract of sale is essentially a roadmap. It sets the stage for the actual sale by outlining all the terms and conditions.
So what kind of things are we talking about?
Well, it lays out what goods are being sold, the price everyone's agreed on, any special conditions, payment schedules, delivery dates, all the nitty-gritty details.
Okay, so it's basically like a promise to transfer ownership in the future when certain conditions are met.
Exactly. You could think of it like getting engaged before the actual wedding.
Uh-huh. So it's like a promise you're saying, we intend to get married, but it's not official until the big day.
Precisely. A contract of sale creates that legally binding obligation, but the actual transfer of ownership happens later.
Got it. So that's the difference between a contract of sale and the actual sale itself.
Exactly.
Okay, I think I'm starting to see the bigger picture here.
Great. Now here's a question for you. How do we know if a contract of sale is actually valid? What makes it legally sound?
That's a good question. I guess there must be certain elements that need to be in place.
You're on the right track. Let's break it down.
Okay, all right.
First and foremost, you need two parties involved, a seller and a buyer.
Makes sense. Can't have a sale without someone selling and someone buying.
Right. But it's not enough to just have any two individuals.
Yeah.
The law requires that both parties have the legal capacity to enter into a contract.
So we're talking about legal adults,
Hmm.
people of sound mind, not minors, or anyone who wouldn't be able to fully understand the agreement.
Exactly. Both
Okay.
parties need to be legally capable of understanding what they're getting into.
So that's our first element, competent parties.
Right. Now, the next essential element is a clear definition of the goods being sold.
Okay, so we're talking about what exactly is being exchanged.
Precisely. It might seem obvious, but it's crucial to be specific, especially when we're dealing with a future sale where the goods might not even exist yet.
Okay, I can see how that could get tricky. Like if someone's selling an apartment that's still under construction.
Exactly. The contract needs to be very precise about what the buyer is getting. Are we talking about existing goods that the seller already owns or future goods that will be produced or acquired later?
Okay, so that's element number 2, clearly defined goods.
Right. Now, for element number 3, the price.
Okay, the price, that makes sense.
The contract must specify the price at which the goods are being sold.
All right, but does it always have to be a fixed number right from the start?
Not necessarily. The price can be fixed in advance, or it can be determined through a specific process outlined in the contract.
So there could be some flexibility built in.
Exactly. And there's a really interesting case that illustrates this point. MS Madhusuthanan v. Kerala Komudi PLTD.
Okay.
This case involved shares being transferred, but the price wasn't a set figure. It was going to be determined later based on certain criteria.
Interesting. So the court actually allowed for a price that wasn't fixed up front.
They did.
Right.
The law recognizes that business deals can be dynamic, and it provides mechanisms to accommodate that.
I see. So it's not always about a hard number. It's
Yeah.
about having a clear process in place.
Exactly. Whether it's a fixed price or a process for determining the price, it all needs to be spelled out in the contract of sale to avoid any disputes later on.
Okay, that makes sense.
Yeah.
So we've got our competent parties, our clearly defined goods, and our agreed upon price, even if it's going to be figured out down the road.
Yeah.
Anything else we need to keep in mind?
We're getting there, but there's one more crucial element we need to cover.
I'll lay it on me.
The contract of sale must explicitly state the intention to transfer ownership.
Okay, but doesn't that seem kind of obvious? If you're selling something, you're obviously intending to transfer ownership, right?
You'd think so, but legally speaking, it's important to make it crystal clear.
I see. So it's about drawing a clear line between simply agreeing to sell something and actually committing to transferring ownership.
Yeah, exactly. You could have a contract that covers various aspects of a potential sale, like inspections, payment schedules, and so on.
Right.
But if there's no clear and unambiguous statement that the seller intends to transfer ownership to the buyer, it won't hold up as a contract of sale.
All right, so let me recap. For a contract of sale to be legally valid, we need 2 legally competent parties, a clear description of what's being sold and agreed upon price, and a very clear statement that ownership will be transferred. Did I miss anything?
You got it. Those are the core building blocks.
Okay, we've covered a lot of ground just now.
We have, but there's still more to explore.
Yeah.
We need to talk about things like offer and acceptance, free consent, and making sure the whole purpose of the sale is legal.
Right, because we don't want to be making deals for illegal things.
Exactly. We'll dive into all of that and more after a short break.
That's good. Let's take a pause and come back to unpack those concepts.
Great. I'm looking forward to it.
Okay, so we've talked about having competent parties and clearly defined goods,
Right.
but I'm guessing the agreement itself also needs to be formed in a specific way,
Right.
For it to be legally binding.
You're absolutely right. That's where offer and acceptance come into play.
Yes, the classic legal dance of proposal and agreement. It takes me back to my contract law lectures.
The good old days.
Can you break it down for us in the context of a sale, though?
Sure. Think of it like a conversation. One party, the seller, puts an offer on the table.
Yep.
They say, hey, I'm willing to sell you this product for this price.
All right.
The other party, the buyer, can then choose to accept that offer, reject it outright, or even make a counteroffer with different terms.
So it's a bit of a back and forth negotiation until both sides are on the same page.
Exactly, and until there's a clear and definite acceptance of an offer.
Yeah.
There's no legally binding contract. It's only when both parties agree to the same terms that we can say a sale is actually in motion.
That makes sense. It protects both sides from being bound to something they haven't explicitly agreed to.
Precisely. And this idea of mutual agreement is also closely tied to the concept of free consent.
Free consent. Okay. Is that just a fancy legal way of saying both parties are happy with the deal?
Well, it's a bit more nuanced than that. Free consent means the agreement was reached genuinely without any pressure, manipulation, or deception. So no coercion, undue influence, fraud, or misrepresentation.
So it's not just about being happy. It's about making sure the agreement is reached fairly and transparently, with both parties fully understanding what they're getting into.
Exactly. If it turns out that one party was forced or tricked into the agreement, the whole thing can be thrown out.
That's good to know. It's reassuring to see how the law tries to ensure fairness in these transactions. Okay, so we've talked about offer and acceptance, and we've established that the agreement has to be based on free consent. What else should we be mindful of?
Well, don't forget about legality.
Legality, of course.
The subject of the contract itself, the goods being sold and the reason for the sale,
Right.
can't be illegal or against public policy.
Of course. We wouldn't want to see contracts being used for illegal activities or anything that harms society.
Exactly. The law simply won't uphold a contract that goes against its own principles or undermines public welfare.
Okay, so to sum it up, we need competent parties, a clear definition of the goods, an agreed-upon price, a clear intention to transfer ownership offer and acceptance, free consent, and legality. That's quite a checklist for a valid contract of sale.
It is, but believe it or not, we've only scratched the surface.
There's more.
There are still more layers to consider, like the important roles of conditions and warranties in a contract.
Conditions and warranties, I remember those terms from contract law, but to be honest, they always sounded like legal jargon to me. The kind of fine print no one ever reads. Can you explain why they're so important in a contract to sale? Maybe give us the layman's version too.
Sure, they might sound like technicalities, but they're actually essential for clarifying the obligations of both the buyer and the seller. Think of them as safeguards built into the contract. Conditions are specific events or requirements that need to happen for the contract to be binding or for a particular obligation to kick in.
Okay, so it's kind of like saying, I'll buy your car, but only if it passes a mechanic's inspection.
That's a perfect example.
The inspection being the condition.
Exactly. If the car doesn't pass inspection, the buyer could have the right to walk away from the deal without any penalty.
That makes sense.
Yeah.
It protects the buyer from getting stuck with a lemon. So how are warranties different from conditions?
While conditions are about things that need to happen before certain obligations are triggered, warranties are more like guarantees about the quality or condition of the goods themselves.
Okay.
Think of them as promises that the goods will meet certain standards or perform in a specific way.
So if I buy a laptop with a 1-year warranty and it breaks down within that year, the seller is obligated to fix it or give me a new one.
Exactly. Warranties give buyers a level of protection and legal recourse if the goods they buy turn out to be defective or don't live up to the seller's claims.
This is getting interesting. It's like we're building a legal safety net around the entire transaction, with conditions and warranties acting as safeguards for both parties. But what happens if one side decides to play dirty and breaks the rules? What if there's a breach of contract?
That's a serious matter, and the consequences can be significant. A breach of contract occurs when one party fails to fulfill their obligations as laid out in the agreement.
Okay.
It could be the seller failing to deliver the goods on time or the buyer failing to make payment as agreed. Those are classic examples.
Okay, so let's say a breach has occurred. What are the options for the party who's been wronged? What can they do to get justice?
Typically, the wronged party has several legal remedies at their disposal.
Okay.
They can sue for damages, which means seeking financial compensation for the losses they incurred because of the breach.
Yeah.
Or they can seek specific performance,
Specific reform.
which is basically asking the court to force the breaching party to actually fulfill their original obligations.
So let's say a seller promises to deliver a rare antique, but fails to do so. The buyer could ask the court to compel the seller to actually hand over the antique rather than just accepting money as compensation.
That's right. Specific performance is often pursued when the goods in question are unique or irreplaceable, where money wouldn't truly make up for the loss.
That makes sense. There's some things that money just can't buy. But speaking of specific situations, I remember you mentioning an interesting case earlier, something about damaged dates.
Ah, yes, the case of Asfar & Co. Ltd v. Blundell.
Okay.
This case involved a shipment of dates that got damaged by sewage water during transport.
Uh-oh.
The buyer refused to accept the dates, arguing they were no longer fit for human consumption, even though they could still technically be used for distilling alcohol.
Wait, so even though the dates had some value left, the buyer could still walk away from the deal? That seems surprising.
That's exactly what the court decided. Their reasoning was that the goods, even though partially salvageable, no longer matched the description in the contract. The buyer had agreed to purchase dates for eating, not for making spirits.
That's a fascinating detail. It highlights how important it is to be crystal clear about the intended use of the goods in the contract of sale.
Absolutely. And it also reinforces the idea that even partial damage can be grounds for a breach of contract if the goods no longer meet the agreed-upon specifications. Every detail matters.
This is making me realize how important precision is when drafting contracts. Every word, every clause has to be carefully considered. There's no room for ambiguity.
You're getting it. For aspiring lawyers like yourselves, mastering the art of drafting clear and comprehensive contracts is a valuable skill. It's about anticipating potential issues and crafting language that protects your client's interests.
Before we move on to the next topic, I want to circle back to something you mentioned earlier about remedies for breach of contract.
Yeah.
You talked about damages and specific performance, but there's another option we should explore: arbitration.
Excellent point. Arbitration is becoming increasingly popular, especially in the business world, as a way to resolve disputes outside of the traditional court system.
Right.
It's often faster, less expensive, and more private than going through a full-blown lawsuit.
So instead of battling it out in court, the parties agree to present their case to a neutral arbitrator who makes a decision that's binding on both sides.
That's the basic idea. And including an arbitration clause in a contract of sale can be a strategic move.
Okay.
It shows you're thinking ahead and that you have a practical approach to resolving potential disputes.
This deep dive is turning out to be an incredible learning experience. We've covered so much ground, from the basic definition of sale to the intricacies of conditions, warranties, breach of contract, and now arbitration. I feel like my legal brain is getting a serious workout.
We've definitely covered a lot, but remember, this is just the tip of the iceberg. The world of sales contracts is vast and full of fascinating complexities.
Before we completely overwhelm our listeners with information overload, let's take a short pause here. When we come back, we'll switch gears and explore some real-world scenarios and case studies that will bring all of these concepts to life. Welcome back to LexTalks.
All right, so are you ready to put all this knowledge into practice?
Absolutely.
Yeah.
Let's see how these concepts play out in the real world. So let's say you're advising a client who's about to purchase a piece of land. They're all excited about the deal, haven't really looked into the details. What's the first thing you tell them?
I think I'd put on my lawyer hat and say, hold on a second.
Mm-hmm.
Before you sign anything, we need to do some digging. Due diligence is key. We got to make sure that the seller actually owns the land and has the legal right to transfer ownership.
Exactly. You can't just take their word for it. You need to verify the seller's title check for any existing claims or encumbrances on the property and make sure all the necessary approvals and clearances are in place.
It's like making sure the car you're buying isn't stolen before you hand over the cash.
Precisely. It's
Yeah.
all about protecting your client's interests. Okay, so let's say the title is clear and everything seems to be in order. Can we just go ahead and finalize the sale deed?
Not so fast. We need to remember the importance of the contract of sale. This is where we lay the groundwork for the entire transaction, outlining all the key terms.
Okay, so we're talking about the purchase price payment schedule,
Yeah.
any conditions that need to be met, that kind of stuff.
Exactly. The contract of sale is like a safety net for both the buyer and the seller. It protects the buyer by ensuring they're getting what they bargained for, and it protects the seller by clearly stating their rights and expectations.
All right, let's throw in a curveball here.
Right.
What if the contract includes a clause stating that the sale is conditional upon the buyer obtaining financing from a bank? But then after signing the contract, the buyer gets cold feet and decides they don't want the property after all. Can they just back out without any consequences?
That's where the concept of conditions precedent comes into play. Remember, we talked about conditions earlier.
Right.
In this case, the buyer securing financing is a condition that must be met before the sale becomes binding. If the buyer can't get that financing for whatever reason, they have a valid reason to withdraw from the contract without facing any legal penalties.
So it's not a breach of contract if a condition precedent isn't fulfilled. That's a good thing for the buyer in this situation.
Exactly. Conditions provide flexibility and a way to manage uncertainties in a transaction. They protect both parties from being locked into a deal if certain essential elements don't fall into place.
Okay, let's flip the script now. What if the seller, after signing the contract of sale, receives a much higher offer from someone else? Can they just ditch the existing contract and sell to the highest bidder?
That's tempting thought. But unfortunately for the seller, they can't simply disregard a legally binding contract. Once the contract of sale is signed, both parties are obligated to fulfill their commitments. Backing out to accept a higher offer would be a clear breach of contract.
So even if a more lucrative opportunity comes knocking, the seller is still bound by the terms of the original agreement.
That's right. The law upholds the sanctity of contracts. It ensures that agreements are taken seriously and that parties can rely on each other to fulfill their promises.
That's a good reminder for everyone listening. Once you sign a contract, you're legally obligated to follow through. Don't be tempted by shiny offers that might appear later on.
A breach of contract can have serious consequences, including lawsuits, financial damages, and even damage to your reputation. It's always best to consult with a legal professional before making any decisions that could violate a contractual agreement.
Absolutely. And speaking of seeking legal advice, this brings us to the importance of having a skilled lawyer by your side when navigating the complexities of buying and selling property.
Couldn't agree more. A good lawyer can help you draft airtight contracts, anticipate potential pitfalls, and guide you through the legal process if a dispute arises. They're your advocate and your trusted advisor.
So for all our aspiring legal eagles out there, if you ever find yourself involved in a property transaction, whether personally or professionally, remember the value of seeking expert legal guidance.
It's an investment worth making.
Well, I think we've covered a lot of ground today. We've gone from the basic definition of sale to the intricacies of conditions, warranties, breach of contract, and even touched upon the role of lawyers in these transactions.
It's been a comprehensive deep dive.
Thank you for joining us on LexTalks. We hope you found this discussion insightful and helpful. If you enjoyed this episode, be sure to subscribe to our channel for more simplified legal discussions coming your way. Until next time, keep those legal minds sharp.
And remember, always seek expert legal advice when needed.